kindly request you all to please stand up for the national anthem.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
Also, I would like to pay a little tribute to our former Prime Minister, Mr. Manmohan Singh, a man of few words but a deep conviction. Dr. Manmohan Singh remains a beacon of economic foresight, diplomatic acumen, and ethnic leadership. His contribution to the Indians' development will continue to inspire generations for years and years. Thank you. Thank you everyone for being here, and sorry for the slight delay. I'd like to extend a warm welcome to each and every one of you for being here. I, Ishika Sinha, on behalf of entire Somireddy Law team, would like to sincerely acknowledge the attendees who are here today for this seminar. So, before we start, I would like to briefly introduce our firm, Somireddy Law Group. Somireddy Law Group is a US-based law firm representing corporate and individual clients, serving their versatile legal needs. Our journey started back in 2017 with our headquarters in Virginia, now expanding our offices in Princeton, New Jersey, Raleigh, North Carolina, San Jose, California, and now India, Hyderabad. We provide legal services to individuals, families, and companies of all sizes across United States in a wide range of practices, including immigration law, litigation, corporate law, family law, criminal matters, real estate, wills, and trusts. Can we just have the AV, please? Now, I would like to introduce you to the founding partner and CEO of Somireddy Law Group, attorney Santosh Reddy Somireddy. Mr. Somireddy received his Juris Doctor degree from University of District of Columbia School of Law, where he was the recipient of the prestigious Earl H. Davis Award for top clinical performance. He has a master's degree in engineering from Bradley University, USA, and a bachelor's degree in civil engineering from Osmani University, India. Mr. Somireddy has a few years of experience as a licensed engineer too. He is licensed to practice around 14 states in the United States. I would kindly request Mr. Attorney Santosh Reddy to please share us few words. Thank you. Please give a round of applause.
Good morning, ladies and gentlemen. Is it clear or? Good. First of all, thank you for being here. I know it's a weekend and it's tough to actually listen to any lectures, especially when it comes to educational lectures, right, over a weekend. But thank you for taking time and trusting us and being here today. We will make the session as interesting as possible. Um, so, by the way, my name is, I think I don't have to introduce myself, right? Okay, good. So, I know we already started late, so I'm going to get into the topic directly. Before we start, a small disclaimer, right? So, anything that we discuss here should be construed as a friendly advice. Okay? This does not create an attorney client relationship. If you have a specific question, please ask it in a generic way. In that way, like, you don't have to disclose the particular details about your company or the individual that you're talking about. Okay, because there is no attorney-client privilege. So, and we don't want you to act upon this information unless you seek the advice of an independent counsel, because every case is unique. So, whatever the information that I'm presenting here today will be a little more generic, but I want to make it interactive session. In that way, it's useful for everybody. Okay, good. Um, I don't need to introduce myself again. You already introduced, right? It's way stuffed. So, apart from immigration, we also handle litigation, corporate, employment, family, criminal, and wills and trusts, right? But my main areas of practice are immigration, litigation, corporate, and employment law. And in certain situations, I do handle some criminal law matters too. Okay. So we help companies like IT consulting firms, engineering firms, and pharmaceutical firms from incorporating their businesses, drafting necessary agreements. Maybe it's an employment agreement or an offer letter or MSA, purchase or everything, right? Whatever you need to start the business. We also help them with procuring necessary licenses and then processing all immigration related paperwork like H1s, green cards, L1s. Not only that, we do handle all sort of DOL and USCIS investigations, right? It's not just about filing the case, it's about being able to protect the company in case there is an issue, right? So we handle all sort of DOL investigations, USCIS investigations. We do handle litigation matters, including breach of contract, non-solicitation, non-compete clauses, payment issues, wrongful termination, pretty much everything that's needed for a running a typical IT consulting firm. Of course, as needed, we also get into like shareholder agreements and everything if there's an issue between the partners of the company too. Okay, so let's get into the topic today. Uh, okay, so first topic is going to be an interesting topic, but this is a topic that we'll be revisiting again at the end of the session because certain things I want to make sure you're aware of it before we get into this. Okay, so how many of you think that the market is going to get better this year for IT consulting firms? Raise your hands. How many of you are optimistic? Okay. Give me one regulation that was implemented during the last term that could have given a death blow to all the IT consulting firms. How many of you are aware of the non-compete, non-compete clauses, the issue with non-compete clauses during the last era, wherein they said like all non-compete clauses will be invalidated against the employees of the company? How many of you are aware of this? Okay, if FTC were to implement that, then pretty much you cannot control any of your employees. Any employee can go and work for anyone. Like there is no non-compete or non-solicitation clause that would apply to them. Okay, but again, we'll get to that one at a later point of time. So first, during the Trump administration, I'm pretty much optimistic that it's going to be business friendly. And also, you might have seen the recent news wherein Elon Musk and everybody stated that, hey, we need more H-1B workers, and that there is a good chance that they might increase the number of H-1B visas also. But they will be making it little more strict because, as you know, there is a lot of fraud going on in the H-1B system. Most of the time this happens because people are not aware of the regulation. It's not that they want to violate the rules, but it's just that because they are not aware of the regulations, they end up violating the rules, right? So one of the main agendas for today's session is to make sure you're educated on these regulations and the typical mistakes that we see that a lot of companies have been doing, right? Because whenever we do an audit on a company, we realize that most of the times companies are becoming like getting into a mess, especially when there is a litigation matter, right? Only because they don't know how certain steps that they have taken in the processing of the paperwork is leading to those issues. Okay, so today we're gonna go through all of those things to make sure like this does not arise in your situation. Okay, so we'll get to this topic later on. So now I will go through the different steps that are needed in operating an IT consulting firm. And then I will also discuss about the typical issues that we see during each of these steps, right? So I want to make it more interactive. So let's go to. No. I think there is another slide. What are the steps? What is involved in running an IT consulting firm? Yeah. So let's go to the typical life cycle of an IT consulting firm. Okay. So step number one, like I'll go through each step. Okay, so we're gonna divide the life cycle of an IT consulting firm into 10 steps. And then for each step, I'll tell you the typical mistakes that I see that a lot of HRs and even the executive team make in during those steps. Okay, so I think I'll probably just turn on this one. Hello, can you hear us? Or I'll just take this. It's okay, I think. Yeah. So the first step in writing, operating an IT consulting firm, right? The first step would be to incorporate the business in the US, right? And then once you incorporate, you try to get the necessary licenses to operate the business, right? That's the first step. So what is the second step? Who wants to volunteer? Bank account? Yeah, that's part of obtaining the necessary, like we can say that it's part of the obtaining the necessary licenses. Tax ID and everything. The next thing is, go to the next one. You will post the jobs, right? You will post the jobs so that people will start applying for positions with your company, right? Then the third step, which is you'll be submitting the profiles to the candidate. So once you post the jobs, then you receive the profiles for each of the individuals, then you submit these profiles to the clients, right? And then you execute the necessary agreements with the clients, right? Fourth step. Then you start hiring individuals, whether they are contractors or or employees, right? Then you execute the employment agreements with them, right? Okay. Fifth step. Then once you enter into these contracts, you conduct their I-9 verification. This is where I see a lot of HRs making mistakes. Okay. Next. Then you process their immigration related paperwork, right? And prepare necessary public access files. Good. Step 7, you pay the employees. Step 8, collect the money from the clients, right? Because you started providing the services, now you need to collect the money from the clients. Step 9, file the tax returns, right? Whether it's quarterly wage reports or the federal income taxes. And step 10, which is the most important thing, is to, what is the most important thing for any company? Step. So this is one of the steps that a lot of people miss. So when you start a company, you should also think about exiting the company too, right? Right? So you need to make sure like you are planning in such a way that you can exit at some point of time. If you don't exit, then it's a waste, right? It's, you make more money by selling the company at some point of time, right? You either sell the company or you merge with another company. That's what typically happens in any life cycle of any company. Okay, so when you start the company, typically, like for example, if I were to start any company, I would think about all these steps. Unless you have an exit strategy, it will be a disaster. Okay, so when you start any company, you need to have an exit strategy also. Okay, and you need to prepare in such a way that you have the best strategy to get the maximum value for your company, right? So whenever, like for example, we work on a lot of M&A transactions, mergers and acquisitions, right? So when we do an audit on the companies, right, we find a lot of mistakes, okay? And the company value will go down drastically if you end up making these kind of mistakes. Okay, so if you have this, like you should have an exit strategy, like you need to know at what point you're gonna exit, right? So I see like a lot of companies, they struggle. For example, some companies, they struggle at 25 employees, right? Some companies, they struggle at 100 employees. They cannot grow further, right? If you are in that position, you either need to make a drastic step, or maybe it's time for you to exit and then restart a new company. Because I see some companies that started like 20, 30 years, 10, 15 years ago, they are stuck at 25 employees. Some of them are stuck at 50 employees. Some of them are stuck at 100 employees, right? When you get to that point, you either need to make a strong decision whether to merge with another company or sell it or whatever, right? So that you get the maximum benefit out of it. Okay? So now I will go through the typical mistakes that we see at each step of this process. Okay? So let's go through the, yeah. Next slide. Okay. In the US, whenever there is a federal law, it applies to all the states. It's same, the regulations are same for all the states, right? So federal law, like immigration is a federal law, like patent intellectual property is federal law. But when it comes to anything else, it's all state specific. So what applies in one state may not apply in another state, okay? Some of the mistakes that I see, a lot of times what happens is individuals incorporate their business only in Delaware. How many of you have incorporated your business in Delaware? Okay. And you run your offices from somewhere else. right? They will have their primary office at some other location, but they will be actually incorporated in Delaware. This is a big red flag, okay? I would not recommend doing that. So you need to incorporate your company in the state where you're operating from, okay? Also, please do not have an office in a state where you're not registered. The other day we were filing an H1B and then we saw that the company had an address in one state, right? And they were actually not incorporated in that state. So if you're running a business without proper incorporation, that means the business does not exist. That if the business does not exist, the H1B cannot be approved. Okay. I know a lot of USCIS officers do not go back and check every time, but if you're caught, then all the petitions that are filed by the company would be considered as null and void because the entity does not exist in the first place. The second mistake that I see, right? How many of you go back and regularly check if your if your company incorporation is active? You check, that's good thing. Check, that's good thing. How many of you do that? Good. A lot of times have been especially during the cap time, right? Because that's when we actually go back and check to make sure that the company is actually in active status, right? Because every year you need to reactivate the status of your company, right? If it becomes inactive and if there is if you enter into any agreement while the status is inactive, or if you file any H1B petition or any immigration related paperwork while your company status is inactive, then it will be considered as null and void, and the petition could be denied. Okay, so this is one thing that I want you to please pay close attention to. Make sure to check your incorporation status on a regular basis. The second mistake that I see, somebody initially starts their business maybe in Virginia, right? Later on, they want to move their office to Texas. Okay, and then they want to be able to use all the credit, the AEIN number, everything from the Virginia entity to Texas entity. So whenever you're doing that one, when you're opening an entity in Texas, you have to open it as a foreign corporation. Unless you open it as a foreign corporation, which is registered in Virginia, you cannot be using that AIN number or the credit for the company. I see a lot of CPAs making this mistake where they just incorporate a new business, because when you are incorporating a new business without actually connecting the original one that's incorporated in Virginia, right? You cannot be using the EIN number or the credit that you have for that company. Let me see. The other thing is, sometimes it may be worth for you to have a single member LLC. I don't know how many of you do single member LLCs. Good. So in those cases, you may be in certain situations, you may be able to take an advantage when it comes to the ability to pay. Because if it's a single member LLC, you can use your personal tax returns also, right? But that only applies to small companies. Like when you're starting, you could start it that way, but very few vendors would be willing to work with LLCs, because LLCs are a little more not formal kind of thing, right? So so LLCs you could start in, you can use it in the initial phase, but later on just move to corporation. Oh, failure to obtain necessary licenses. So for example, I'll take the example of Virginia itself, right? So in Virginia, you cannot be operating any business without taking the license from the county, right? So, for example, in Fairfax, a lot of companies, they miss doing that one because they only think about the requirements in other, for example, if they have previously done business in other states, maybe New Jersey, right? Which may not require the local licensing. But there are other states that require local licensing. And if you run a business without obtaining those licenses, then it will have a huge effect on the company. Okay, so this could also, like, if any petition is filed in violation of the state laws, right, it could be denied for that reason too. So you have to be very careful in knowing, understanding about the local licensing requirements before you start operating the business. Okay. Lot of companies operate from home, right? It's perfectly okay to have a home-based office as long as none of your employees will be working from home, right? Except you, who is the CEO of the company. If nobody else is working from that home office, then it's perfectly fine. But certain counties and certain cities, or like maybe the HOA, also have restrictions on those. Okay, if there is a restriction on operating a home-based company, then you should not operate it from there. These days, we have been seeing a lot of RFEs whenever we file H1B petitions using a home-based business, right? So at that point of time, you need to show that you're not violating any state or local laws by running a home-based business. Okay, but please make sure you don't mention that the employee would actually be working from that home business. If that happens, they need to get special permission. Okay, good. Let's go to the next one. Yeah, good. This will be an interesting one. How many of you do job postings? Good. When you're posting jobs, do you say that you're willing to sponsor H1Bs? Do you mention H1B sponsorship is available? So what would you state? Would you state H1B sponsorship is available? Doesn't matter. The rules have been the same for the past many years. You do mention H1B sponsorship is available, right? Good. That's completely illegal. You'll be in big trouble for that. There are a lot of companies that had to pay fines for that reason, because they mentioned that H1B sponsorship was available, because it's a pure violation of Equal Employment Opportunity Commission, EEOC regulations. Okay, next. How many of you state anything related to OPT, CPT, or anything like that? How many of you mention about OPTs, CPTs when you're doing ads? That's also illegal. I'll get to that one. How many of you mention ads stating that you need someone who is a GC holder or a citizen? You do that? K-Force had to pay $900,000 as fine few months ago because they were placing ads stating that the position requires GC or a citizenship. How many of you are aware of this? You are aware of this? That's good. So you could actually look up DOJ versus K-Force, wherein Department of Justice came back and said that, hey, even if the client requires, even if the client states that they need someone who is a green card holder or a citizen, you still cannot ask for that in your job posting. Anywhere, job boards, company, like any of your websites and all those things. There are actually a few individuals in the US who are actually trying to look for those job postings, and then they'll send you demand letters. There was actually one guy, I think, I don't remember his name, was from Florida. So he sued maybe 50, 60 companies, IT companies. Every time they post an ad saying that, hey, we need someone, we are willing to sponsor H1Bs, he would just send a demand letter to them, and then they would not reply to that. then he was gonna go and file a case with the EEOC, right? And then these companies, instead of fighting the case, they would just pay him $25,000-$30,000 and settle the matter. And they would not discuss this outside. Actually, Dice has flagged him too. I don't know. I cannot remember his name. I think it's George or Thomas, one of these two, but I can send you that information. So he filed like cases, like even some of my clients have been victims of his actions. Okay, so please be very careful when posting the jobs. Now you may be asking, hey, how do we post the jobs correctly, right? So instead of stating that H1B sponsorship is available, what can you state? Huh? Okay. Okay, we need someone who should be authorized to work, or visa sponsorship available. That's perfectly fine. You could say that visa sponsorship is available, but you cannot say that H1B visa sponsorship is available. Okay? Instead of stating that you need someone who is a green card holder or a citizen, right? You could just mention that you need someone with security clearance. Okay? And do not mention that H1B visa sponsorship is not available. A lot of people do that also. On the ads, they mention that H1B sponsorship is not available. Even that is illegal. Okay? Let's just show some of the sentences that are illegal and then legal ones. H1B sponsorship available. That's actually incorrect. OPT CPT applicants are welcome. That's also incorrect. No H1B OPT or CPT or H4EAD. That's also illegal. Green card citizenship needed. That's also illegal. Not okay. So how many of you are familiar with the wage transparency laws? How many of you are familiar with the wage transparency laws? Good. How many of you have offices in the state of Washington? You have an office in Washington? Good. I'll tell you something about it. Okay. So how many of you actually have placed at least one of your employees in the state of Washington? Most of you have done that. Okay, good. So look up Washington wage transparency laws. So there is a company called Inside Global. How many of you know about this company? Wow, okay, good. They actually had to pay $5,000 for every individual that had applied for a position with them, because they violated the wage transparency laws. You could actually look it up online. Just type in wage transparency and then type in Inside Global. You'll be able to see that one. They had to pay $5,000 as fine. For example, if they had like 20 job postings and 100 people have applied for it, right? For each of those, everybody who applied for a position with them were able to get $5,000 in settlement, plus the attorney fees. You know what the mistake that they did? Because most of the states now have the wage transparency laws, which require you to actually mention the salary range for the position. If you miss doing that one, then you're held liable. Okay, so especially in Washington state, like I'm giving this example of Washington state because Inside Global pretty much everybody knows, right? So since they had to pay this fine, so that's why I want to give it to you as an example, right? And the worst thing about these regulations, right? So Washington state laws for wage transparency not only applies to those companies that have their office in Washington, but also any company that operates in the US, which has more than 15 employees, as long as at least one employee works from the state of Washington. So if you're a New Jersey based business having 30-40 employees, and if at least one of your employee has worked for Microsoft, right? Then you'll still be subject to the Washington's wage transparency laws. Actually, there is a newsletter on our website, so maybe one of you can share it. Anyone from the litigation team here? Shreyas? Or Vishika? Sorry. One of you please share the link for the newsletter that we have written. We have clearly cited the issue that happened with Inside Global also. And this not only affects the employers in the state of Washington, but also employers throughout the country. Unfortunately, there are a few attorneys who look for such job postings, and then if they like, then just send you a demand letter. You don't want to be a victim of that one. Shreyas, there is a newsletter on Washington Wage Transparency on our website. Okay, share the link with them. Good. So, and the correct way of posting the jobs. You could mention visa sponsorship is available. Okay? Next. Security clearance needed. Must be authorized to work in the US. Right? So these are the things that you could mention instead of stating that OPT, CPT, or H1B, or H4EAD, or anything like that. Some of you may be asking, Santosh, what is the difference between stating H1B sponsorship available and then visa sponsorship is available, right? I'm surprised that nobody asked that question. Can someone think of a reason why stating visa sponsorship is available is legal, whereas stating that H1B visa sponsorship is available is illegal? Yes. Yes. Right? So if you specifically mention H1B sponsorship is available, that means you are discriminating against other visa holders. Right? So if you are stating that GC green card or citizenship is required, that means you're actually discriminating against people who are authorized to continue staying and working in the US based on asylum or any other applications. Right? So if any of your job postings are in violation or are in discriminating in nature, then it's a problem. There are a lot of EEOC complaints that happen, and then people just pay money to settle it, and then there are a lot of companies that got into trouble also. I mean, I'm going to ask you another question. How many of you know that Apple had to pay, I think they paid $50 million or $5 million because there were violations with their perm job postings? Is it 50 million? How many of you are aware of this? Okay. Good. I'll get to that in some time. Okay? Because there are a lot of things that you need to be aware of. It's not just about running the business. You need to be able to protect your business, and then you need to make sure nobody comes and sues you for any reason. Right? Okay. I'll get to that in some time. Are we clear on these, or does anyone have any questions? Okay, let's do one thing. I'm going to take some questions for every step. Okay, so far, do you have any questions on step number 1 or step number 2? Anyone has any questions regarding the job postings? Okay, so now that you did hear about this one, what is the first step that you would do? For example, you're posting your job, like you're where are you based out of? Where is your company based out of? Atlanta, right? Okay, so what is the first step that you would do?
First, I'll remove my old post.
Okay, next.
Later, I'll make differences, as you said. Like I'll connect myself onto the posting, and I'll start posting onto the different job platforms.
Okay, what is the important step that you need to do? Another important step that you need to take. Look up the wage transparency laws in your state. Right? That's a very important thing. I don't know, like if you're seen, when you're doing the GC postings, right? Some of the newspaper ads may be asking, hey, you need to mention the salary. How many of you encountered this? You encountered this one? You know why they are doing that one? Because that particular state actually requires you to post, has strict wage transparency laws, and that newspaper agency also could be held liable for that reason. So that's why they don't post any of your jobs until you mention the salary. Not all states are doing that one, like not all states have such stringent laws, but they have, but still it's a violation if you don't post it, right? So, and even New Jersey is moving towards requiring having wage transparency laws. Washington, California has one, and they're pretty strict about it too. So be very careful. The other issue with this is, since you'll be mentioning that the position requires travel or relocation to various unanticipated client locations throughout the US, right? So even though the company is in a particular state, maybe in New Jersey, right? Since you're making this job available for candidates from other places, because you're saying that the person could be working from other states also, right? These laws will also come into picture. So whenever you're doing these job postings, please make sure that whatever the posting that you're making will pass the minimum mustard required, like in all these states. Is that clear? Okay, good. Next. Okay. I'm going to ask you one thing. So now you have posted the job, right? And somebody applied for a position. Right? You posted the job on the job board, somebody applied for the position. Now there's a client who is like, the person applied for a Java position, right? And there is a client that is looking for a Java developer. Before you submit, and what are the steps that you need to take? What would you do? Huh? Go ahead. Yeah, you're right. You're right to represent. Next. A lot of companies make mistake here. Make sure you have a proper agreement with the beneficiary. Like when I say beneficiary, the employee or a prospective contractor, right? Clearly stating that you have the right to submit his resume to the client. Okay, I'll tell you why this is very important. That's one thing. Next, you should have the exclusive right. Not just right, but exclusive right. And that he did not enter into any contracts that will conflict with this position. Right? And then also mention about the non-compete, non-solicitation clauses. Okay, because what happens is, I'll give a small example. Assume that somebody applied for a Java developer position with you, okay? And of course, you need to clearly mention which client you're submitting his resume to. That's also very important. So assume that you took somebody's resume, you submitted it to a client. Now, the employee, but the employee does not know that you submitted this to a particular client, right? Now the employee is working through some other vendor to submit his resume to the same client, right? Although you have it, because a lot of times they have these generic agreements where you'll have non-compete clauses and all that stuff. But you cannot use it against the employee until you make the employee clearly aware that this is the client that you're submitting it to, okay, and that you have the exclusive right. The worst thing is the employee can come back and sue you for the reason. For example, if he is losing his job because you submitted his resume without his knowledge, then he could actually sue you for damages. So it's very important that you have a proper agreement in place such that you have the exclusive right to represent, to submit his resume to the client, and then the non-compete clause and all the stuff. Okay, and also this is where you need to actually have the agreement, the clause stating that if the client accepts your resume and if you pass the interview and all that stuff, you have to join the client. Okay, not only that, you could also put in a clause stating that, hey, if you join this client, then you'll be receiving so much bonus, and in exchange for receiving this bonus, you agree that you'll continue working on this project for such a long duration. What happens is, a lot of times we see that the employers try to keep the early cessation penalty in their employment agreement, right? So what they do is they have a clause stating that, hey, you cannot leave the company for like 2 years or whatever, right? So if you have such clause in the employment agreements, it could be a violation of the Fair Labor Standards Act. So look up FLSA, I think it's 62 or 71. Anyone from the litigation team? 62, okay. Look up FLSA fact sheet 62, and that clearly states that an employer cannot have a lease cessation clause for non-immigrant H-1B workers. But again, there is an exception for that, right? The employer can have such clause as long as it is allowed by the state law, right? So instead of clearly having it only for the H-1B employees, since you are having that at the initial stage, which is at the time of submitting the resume to the client, right? It's not just for the H-1B workers; it's for everybody. That will be acceptable. Is that clear? Okay. Second thing is, make sure you do not have any illegal terms in your employment agreement. If you have one illegal term also, it will work against you. Even if it is not the if it's not leading to the cause of action, you still could be held liable for that. How many of you had any dual investigation in the recent past, wherein an employee went and complained to the Department of Labor stating that you did not pay the salary or whatever? Did anyone have any dual investigation in the recent past? Okay. The first thing that they're going to ask you in that one is regarding the public access files, of course. The second thing would be they'll ask you, hey, did you have any clause in your employment agreement that would restrict the employee from leaving the employment within certain period of time? That's the first question that they typically ask, because they're actually looking for that early cessation penalty, right? So please make sure you do not have those clauses in the employment agreement itself. Is that clear? Oh, the other thing is, for example, now when you submitted the resume for the candidate, right, make sure to have a liquidated damages clause. Okay, do not, because if you leave that one, then it will be on the burden of proof will be on you to prove that you have actually incurred damages. Okay, which is very subject to, and it will be a headache for you to defend yourself, right? Instead, I recommend having a liquidated damages clause saying that, hey, we will, like, because since it's tough to actually calculate the actual damages, so you'll be incurring like maybe $15,000 whatever as liquidated damages. Is that clear? Good. Oh, the other thing is, a lot of times what we see, immigration is a federal law, right? The same rules apply throughout the country. Whereas whenever you are looking at an employment agreement or any litigation matters, these are all state specific. The agreement that is valid in one state may not be valid in another state. Okay, so whenever you have an agreement that is drafted, right? So you need to look up the choice of law for that agreement and make sure it is reviewed by the attorney who is licensed in that particular state, right? Even ourselves too, right? So although we practice immigration in all 50 states, we practice litigation matters only in 14 states. Only in those 14 states, we have the authority to review the agreements and guide you on those. Okay, if you want to look up the 14 states, maybe you should just go to the slide, initial slide, where they can see the state licensures. Make it quick, if not, we'll just move on. Are you able to see that slide? or you could just go to my profile. Okay, so I myself can review the agreements only in these states: Arizona, District of Columbia, Georgia, Illinois, Maryland, Michigan, New Jersey, New York, North Carolina, Ohio, Pennsylvania, Texas, Virginia, and Washington. So I can represent any clients in litigation matters if they are from these states or if the choice of law is from these states. So if your company is not in one of these states, then it's tough for us to represent you. Okay, so let's go back to this. Okay, next thing. Oh, go back. Or I can just, okay. Make sure when you are entering into an employment agreement with the candidates, right? You clearly mention that the employee cannot directly contact the client, because most of the times what happens is the vendors have clauses in their agreement that says that, hey, if an employee or if an employee or a contractor of yours contacts the client, then you'll end up paying liquidated damages, right? Or if the employee tries to seek any other benefit, right? Maybe it's a different job or whatever, then you have to pay so much in penalty, right? So you got to make sure that you have certain clauses in the employment agreement that will restrict the employee from doing that. Okay. Also, you need to have an indemnification clause. What's an indemnification clause? For example, if somebody does something, like for example, I enter into a contract with you to place one of your employees at a client, right? And the employee does something, right? The client is going to sue me, not you, because I have the contract with the client, right? So if I have an indemnification clause with you, then whatever damages that I incur, I can put on you. So that's an indemnification clause. Okay. Also, when it comes to the non-compete, non-association clauses, the clauses that are applicable in one state would not be applicable in another state. I'll give a small example. I'll give an example between the same clause, how it applies in Virginia and New Jersey. Okay. Assume that in the non-compete clause says that, hey, you cannot work for this client for 1 year, right, after you leave our project, right? The same clause, if you have in Virginia agreement and the New Jersey agreement, New Jersey the judge may allow that one, but Virginia judge would not allow it. Okay, there are a lot more factors that they look at in these situations. There is something called blue pencil doctrine also, wherein the judge can make some certain modifications to the regulation, to the agreement, and to implement it. So, but it's a total different topic, so not going to go in more depth with it. But I want you to thoroughly, like whenever you have these clauses, make sure it's as per the state law that you are using as a choice of law. Okay. Also, be very careful whenever you have an employee working from the state of California. How many of you have employees working from the state of California? Good. Be very careful with it. Do not, even like for example, even if they breach a non-compete clause, do not sue them. Okay, I'll give one of the worst statutes that they have is that, for example, if you have an employee who has breached the non-compete clauses, but he is based out of California, he's working from California, right? Even if you are able to obtain an injunction order in your particular state, they can actually file a case against you in California, and they can seek all sort of damages. So the rule of thumb is, if you have an employee working from the state of California, do not sue them based on non-compete clause. Right? Of course, there are other ways to get around that one, but usually if it's an employment agreement, if you have a non-compete clause and the employee is based out of California, then try to avoid it. Oh, go back. How many of you are familiar with choice of law and venue? Okay, so choice of law is the state speaks about which state law applies, right? And the venue speaks about where you can file the lawsuit. So for example, if you are a company based out of New Jersey, then you want to keep the choice of law in New Jersey as well as the venue also in New Jersey, because if you have to file a lawsuit in some other state, for example, if the other party is in Michigan, right? Instead of you going and filing a lawsuit in Michigan, you would want them to file a case against you in your home state. So you got to be very careful when reviewing the choice of law as well as the venue. Also, make sure like you need to decide whether you want to go for a litigation in the court or an arbitration. Okay, please do not have arbitration clauses in your employment agreement. Whereas if you have an even for example, if you are giving subcontract, like if you are signing an MSA with a client, right? Make sure even they don't have an arbitration clause. Okay, you could because if they stop paying you, right? For example, what happens is usually people have arbitration clause and they'll stop paying you for the last 1 month or 2 months. If they have the arbitration clause, then you cannot file a lawsuit in the court. You have to go through the arbitration process, which is going to be very expensive, okay, and a cumbersome process. Whereas if I were to give a subcontracting agreement to somebody, I would try to put that arbitration clause because I don't want them to sue me easily. Is that clear? Okay. Anticipatory repudiation clauses. Okay, this is also very important. So for example, you have placed one of your employee to work through a vendor, right? And the vendor has stopped paying you, like, or maybe they are delaying payments, right? But the vendor has the contract agreement between you and the vendor states that hey, you have to continue providing the services until the end of the project, right? If not, you have to pay damages, right? So now you're kind of stuck, right? Because you cannot stop providing the services, because if you stop providing the services, then you are violating the agreement itself, right? But here you're not receiving money from the vendor also, right? In those cases, if you have an anticipatory repudiation clause, right, stating that, hey, if there is any delays in receiving payments from the vendor, you can actually send them a letter saying that, hey, you have to cure this, right? If you do not cure this, then it's a violation of the contract and that breach of contract, and that we can actually cancel the contract. So make sure to have those clauses in your agreements. I think I've been through this one. Oh. How many of you know about ambiguous terms? Okay. So whenever, I'll give a small example. Whenever an employee reaches out to us saying that, hey, Santosh, like I have a new, like I want to join the client directly or whatever, right? When we look at the contract, if we see that there's an ambiguous term, when I say ambiguous term, if the terms of the contract are conflicting, right? So most of the time what happens is the offer letters and employment agreements, they copy it from somewhere, right? So if you're doing that one, then there will be clauses which could be contradicting with each other. Whenever you have an ambiguous term, when there is ambiguous term which is not clear or conflicting terms, right, it will be looked up against the master of the contract. So who is the master of the contract? The person who drafts the contract, right? So for an employment agreement, who is the master of the contract? Employer, right? If it's a vendor agreement, who is the master of the contract? The vendor, right? So whenever you have a term that is either ambiguous or inconsistent, right, or conflicting, then the term will be looked against the master of the contract. So be very careful with your employment agreements. If there is any clause in the employment agreement that is ambiguous, then you'll be the losing party. Is that clear? Good. Next. Okay. So I mentioned about the elicitation penalty, right? Look up FLSA fact sheet 62. Okay, so that one clearly says that you cannot have an early cessation penalty for a H-1B worker. But again, there is an exception for that, right? If it is allowed by the state law, then you can have the liquidated damages, right? So you need to make sure that when you have this clause, it is as per that state law. I think we went through this one also. Please make sure you don't have any inappropriate fee payment clauses. Okay, especially what happens is a lot of times the individual will not be on the project, and then you'll say that, hey, if you leave the company within certain period of time, you have to pay so much in damages, right? That's a pure violation. Okay, although you're not clearly mentioning that it's visa applicable fees, the Department of Labor is still going to go after you for that. Oh, the other thing is, what is the statute of limitations whenever there is a DOL violation like this, wherein an employer took money for filing H-1Bs, or like if there is any such issue? What is the statute of limitation? You know the statute of limitations, right? Statute of limitations is the time period that the Department of Labor can go back to look at the violation. Can anyone guess? Lot of employers get confused with it. It's just 1 year actually. Yeah. Even Department of Labor, they are smart. They will not tell you that it's only 1 year. They'll start investigating the matter, and then once we get involved, and then we can like nail them down. Right? They cannot go after everything. Their review period is also very limited. They just can't do whatever they want to do. But you need to bring that up to them. How many times do you have FDNS people like visiting your office and asking for all sort of documentation? Employee, but also documentation related to everybody else. How many times have you encountered this one? Okay. As of today, the compliance with FDNS visit is still voluntary, right? Again, that's going to change from Jan 17th, but as of today, they still don't have that right. It's just voluntary. So whenever you have any, like, do not provide any incriminating information to the officer, right? If you think that something is going wrong, you can just tell them, hey, or talk to my attorney, I don't want to provide you with any more information, and then we can handle it from there. Okay, but if you end up providing incriminating information to them, then we are screwed big time. Because now they have access to everything. Is it clear? How many of you have moonlighting clause in your employment agreements? You do? Okay. How many of you have it? The reason why you need to include a moonlighting clause in employment agreement, especially and with the indemnification clause, is that, so for example, if the vendor comes to know that the employee was actually working for some other client too during the same time, the vendor can actually sue you, stating that you submitted fraudulent timesheets, right? Because you submitted stating that you worked 8 hours for this client, right? At the same time, the employee was working for somebody else, right? So the client can actually sue the vendor can sue you, right? So in order to protect yourself, you need to include the moonlighting clause and then have an indemnification clause stating that the employee cannot be working for some other company and that they will have to indemnify you for any damages that you'll be encountering for that reason. Is that clear? Oh, let's stop here. How many of you ask for H-1B documentation when somebody applies for a position? You do? How many of you do that? Be frank. So what do you ask? How do you ask that? So if somebody applies for a position and if you see that the person's name is Santosh Reddy, right? You would directly ask them for H-1B copy, right? Or OPT, CPT. How many of you know that it's a pure violation? How many of you know that it's a pure violation? It's a discriminatory act. Okay, I'm going to ask you another question. How many times have you seen your vendors asking for those specific documents instead of saying we need I-9 documents? Why do they ask for I-9 documents instead of asking for H-1B or citizenship card or GC card or whatever? Why do they ask for I-9? They could ask for example, see the way you asked, right? If you looked at Santosh's name and you asked for his H-1B, right? Similarly, why is it that the vendor is not asking you to provide that particular document directly? Instead, they're asking you to provide the I-9 documentation. Why do they do that? Yes, you're right. Who said that? That's right. Asking for a specific documentation is considered as discriminatory in nature. Okay, it's not only racial profiling, but also discriminatory in nature. If somebody can clearly document that, hey, this HR person is asking for this specific documents just by looking at my name or whatever, right? And if the person doesn't get hired, they can file a lawsuit against you. Okay, so you should not be asking for any particular document. What you need to do is you need to tell them, hey, you need to complete the I-9 form and send it to us with documentation to prove that you're authorized to work in the US. Right? Is that clear? Because they're like, I'm sure like you may not have encountered this because most of the employees or the applicants would also not know about these regulations. But if somebody wants to give you a hard time, yes, they can do that. So please do not ask for a specific document. Instead, ask them to complete the I-9 form and submit it to you along with the evidence like documentary evidences to prove that they can work for you or they are authorized to work in the US. Is that clear? Good. How many of you actually maintain public access files? Good. Can one of you raise your hand? I'm going to ask you a question. How many of you, okay, how do you arrange your public access files? For example, you filed Santosh H-1B transfer, right? So you have, what kind of documents do you put in this HR file?
I will put LCA along with PAF.
You'll put LC along with PAF, okay.
Yeah.
Do you put the any other HR document rated like I-9 documents also with that?
Yeah, definitely. We would even put the I-9 verification document that has been done for the employee.
You put it in the public access file?
No, not with public access file. In the employee folder, we are saying.
Okay, do you actually mix the public access file with the HR file?
No, we never. We only
never.
put LC and PAF.
Good. First thing, public access file is not for a particular individual, right? It's for the particular LCA, right? Never ever club the LC in the public access file with the HR file. Lot of HR individuals make this mistake, wherein they club the HR file with the public access file. The Department of Labor officer has no right to look at your HR file directly. Okay, they can only look at your public access file. So never ever keep these two things together. Lot of times what happens is they arrange the public access file based on the employee name. Don't do that. Keep it as per the LCA. And how long do you maintain these public access files? Why? Okay, so assume that I file an LCA today, right, for a H1B transfer. Huh? No. Good. You need to see, the thing is you have to limit your liability. Okay, do not keep a public access file with you unless it's needed. If it's not needed, trash it. Don't keep it with you. This is the biggest mistake that a lot of people do. What happens is if there's a devolved investigation, they provide all the public access files, right? And if there is a mistake in a public access file, they'll be, of course, nobody is perfect, right? You'll be doing some mistake, or there'll be one mistake or the other in public access files too. You want to limit your liability. The way you would limit your liability is you will maintain the public access file for the duration of the LCA plus 1 year, or until the day you withdraw the LCA plus 1 year, whichever is the earliest. So for example, assume that you have an employee who has been working for you, the employee left, right? Of course, you will be doing the proper termination, all that stuff. I'll get to that later on. Apart from the termination, if you want to limit your liability on that public access file that you used based on that LCA, right? What you need to do is you need to withdraw the LCA. If you withdraw the LCA on that day, your liability ends 1 year from the day you withdraw the LCA. Right? After that, you can remove that file. So if there's a dual investigation, you clearly say that, hey, these are the valid LCAs that we have for the company, right? So this LCA is valid until so-and-so date, so we're keeping public access file only until so-and-so date. Once you hit that date, remove the public access file, don't keep it. Is that clear? Because the more number of files that you have, the more number of mistakes that you make.
So I have a single doubt here, sir.
Yeah.
Yeah, for one employee, we might be filing 2 or 3 LCAs, right? Considering his amendments.
Good.
Right. So in that case, how do we maintain the public access file?
Nice. That's a good question. So if I were to be in your shoes, this is what I would do. For example, if I file an amendment for a candidate, right? As soon as H1B, once that amendment goes through, then I withdraw the old LCA. Because when I withdraw that old LCA, my liability ends 1 year from that day I withdraw the LCA, and then I can remove that file.
Okay, you mean to say only the latest LCA would be the public access file, right? The one which you filed.
Yeah.
Thank you, sir.
So it's nothing to do with the employee itself. It has to do only with the LCA. If you have a valid LCA, you have to keep public access file until the validity of the LCA plus 1 year.
Understood, sir. Thank you.
Okay, good. How many of you keep the recruitment reports whenever you do the GC cases, right? How many of you keep the recruitment reports with you? Only one person? 2, 3, 4? You need to have the recruitment reports. I know Department of Labor has not been auditing these reports for a long time, but they can always come back and audit these. You need to, whenever you do conduct recruitment, you have to have those public access, the recruitment reports available with you for 5 years. This is what you need for 5 years, not the public access file. Okay, one of the reasons, sorry, are you recording all this? Okay, that's fine. But don't make it public though. So, shit, I lost my chain of thought. Huh? Or recruitment report, right? So whenever you conduct recruitment, right, you need to maintain those records for 5 years from the day you submit the perm application. Lot of people don't do that. Okay, not only that, one of the biggest challenges with the public access file, right, is that lot of times you will not have documentary evidence to prove that the LCA posting was done properly, right? So you had to be very careful with that too. So you need to limit your liability to as much extent as possible. Okay, so since we got into the GC public access file, I'm going to tell you about the typical mistakes that I see when it comes to processing GC applications. Assume that you have 3 employees working in, you can go back and check your records on this one, by the way. Okay, so assume that you have 3 employees working in your company, employee A, employee B, and employee C, right? Employee A has a all 3 of them are currently working as program analysts, right? Employee A has a master's in computer science, employee B has bachelor's in computer science, employee C has some other degree. The first time around when you submit employee A's file for prompt processing, they'll say that program analyst requires a master's degree in computer science. Is that what you encounter? 6 months down the lane, you submit employee's B file, then they'll say that same position requires a bachelor's degree in computer science. 1 year down the lane, you submit another profile, then they'll say that same position requires something else, right? Here, the issue is not with getting perm certification, because the perm will get certified because the officer is looking at one perm at a time, right? But if there is an audit, the way I mentioned, right, they can come back and audit your files for 5 years. And at that point of time, if they realize that you are requiring inconsistent position requirements tailoring to the candidate, they might do a big audit on the company. Is that clear? How many of you understood whatever I just mentioned? Go ahead. You had any question? Oh, you understood, yeah. Because this is the typical mistake that lot of employers make. What they try to do is, they try to match their current H1B job title with the beneficiary's qualifications and try to come up with the position requirement, which is a big no-no. The first thing is, H1B job title need not match with the GC job title. How many of you know this? How many of you try to match the H1B job title with the GC job title? Okay, because the H1B job title could change from time to time, and GC is for a future employment, right? So for example, if you place the candidate on H1B for one client, they might say that the position is Java developer, right? If you move them to a different client, they may say that Java consultant, or maybe consultant, or a software developer, right? The job title could be changing from client to client. Similarly, you will most probably be changing your H1B job title also, right? The second mistake that I see with a lot of GC applications, right? So assume that you send the explain letter for one of the candidate, and it has a bunch of skill sets. C, C++, Java, HTML, .NET, MySQL, and all, SharePoint, everything. They try to put all these skill sets as the position requirements. How many of you do that? Wherein, like, how many of you seen ads which has bunch of skill sets in it? Pretty much a lot of people do that, right? That's actually incorrect way of doing it. Instead of mentioning all those skill sets, what you could have done is you could have just mentioned SharePoint and Java. The reason for this is, anyone who knows SharePoint already know .NET, right? There is no reason to include .NET separately. You did not get any advantage by including .NET there, right? But by unnecessarily including, similarly, anyone who knows Java already knows C, C++, HTML, MySQL, all those things. By unnecessarily including those skill sets as a requirement, it looks like as if you're tailoring the position to the candidate. Okay, all of these things will typically come into picture if there's an audit. Because, and then the other mistake that I see, right? Sometimes it looks funny. So the position will be in SAP position and the position requirement will be in Java. Just because the employee had experience in Java, they try to put that as a skills required for the position. They don't look at the correlation between the actual position itself and the skills required, right? And what happens is, if there is an audit, then the employer has to provide an affidavit confirming that this is the minimum skills required for the position, which is incorrect. And if any technical guy, if they look at it, it will be a big investigation. So you got to be very careful with that. So we'll do the first 5 and then take a like 10-minute break, and then we'll get back to this. Document, the employee must complete section 1. Oh, especially with OPTs, right? OPTs and all, there is a lot of disconnect within the HR team members, because of which they don't complete the I-9 form or E-Verify on time. They'll enter the information onto the service portal, but they will not be like conducting the E-Verify or I-9. So this is very dangerous. So you need to synchronize the process within your company such that the I-9, you need to try to complete it on day 1. Right? Although you have 3 days, try to complete them on day 1 itself, day 1 or day 2, 1 business day. Right? Same thing for E-Verify. Because these days we have seen an increased number of I-9 audits. How many of you have encountered I-9 audits in the recent past? Okay. Okay. Because a lot of people approached us because they had an I-9 audit. Okay. So you got to be very careful with the timeline. Should we take a few minutes break, and then, because you have 10 slides, right? Yeah, we'll take a 5-minute break or 10-minute break if you want to. Yeah. Okay. So first of all, let me tell you the reason for having a public access file. Okay. The reason for having public access file is that they want to make sure that a typical US worker knows what is happening in their office with respect to hiring a a foreign worker, because that will ultimately affect their wages and everything, right? So the main aim of Department of Labor is to protect the local workforce. So anything to do with, whenever we deal with anything to do with Department of Labor, their main aim is to protect the US workforce, right? For that, they want to make sure, of course, since that is, of course, although that is the main aim, with that comes in, they want to make sure like the foreign workers are not treated badly, or they have very good, they have decent work environment, everything, because that will ultimately affect the US worker, right? So they want to see enough documentation regarding the positioning, what the benefit, like what kind of benefits the employees actually, the foreign worker is getting. So first of all, we'll put the LCA, right? And then they need some documentation to prove that the LCA posting was actually done. That means the information was accessible to any US worker working at that location. So, and the other thing is, you need to post the LCAs. The LCA posting has to happen at the work location, wherever the beneficiary is working from, not from the petitioner's office or anywhere else. It has to have, because that is where the labor market is getting affected, right? Which is the ultimate work location. So you include the wage memorandum document, right? Which clearly identifies the wage that you're paying the candidate, the benefits that you're paying, and everything that you're paying the candidate, and also the way you came up with the prevailing wage for the position, and the LCA. That's pretty much it. Oh, what goes on the notice board is a small part of what is in the public access file. Because on the notice board, all you need to put is whatever the salary that you're paying, the LCA itself. And then you need to provide them with a guideline as to who they can contact in case they have a question or whatever. Right. That whole documentation is going to go in the public access file. Right. Should we take a 5-minute break? Yeah, let's do it that way. And then after this, we'll have another 5 slides. And after which I'm going to go through the H-1B modernization rules that are going to affect, that are going to go into effect from Jan 17th. And then in the meantime, if you have any Q&As, we can, let's do one thing. We'll have Q&A session first for a few minutes, and then I'll start the next 6 to 10 slides. Okay. Also, see, I want to make it beneficial for everybody. So if you have any questions, please feel free to ask. There's nothing like a silly question. So if you have any questions, you can ask me. Okay?
Sir, I have a small question.
Sure, go ahead.
Regarding wage laws.
Uh-huh.
So let's say our office is located at New Jersey, and employees work from home from Florida or Texas, some other state. So in this case, which wage law needs to be considered?
Good. So since the company is based out of New Jersey, you would apply New Jersey law. Okay, but if whenever you have a situation wherein if you mention that the position, the person can work from anywhere in the country, then make sure like you need to look up the state law in that particular state too, where the beneficiary is working from. So for example, your company is based out of New Jersey, right? And you have at least one employee working in the state of Washington, right? And if you have that more than, I think, 15 employees, then you are subject to Washington wage transparency laws. But when I say Washington wage transparency laws, it only applies if the position is available for somebody to work from Washington. So for example, if you post an ad saying that the work location is in New Jersey, then you don't have to worry about it because the position is not available for somebody in Washington to apply, right? But when you are doing GC processing, right, here you are stating that the position is available, right, for anyone in the country, right? Especially you're stating that the position requires travel or relocation to various unanticipated client locations throughout the US. That means the position is available for somebody from the state of Washington also, right? So it's better if you just include the wages in that one.
Okay, sir. Thank you.
Okay, but if it's only specific to New Jersey, then you don't have to.
Yeah, thank you.
Yeah. Again, a small disclaimer, New Jersey actually has the wage transparency laws now. Yeah. Should we take a 5-minute break? Yeah.